The CPI report, Child Protection in Iowa, brought to you by Vocal, Victims of Child Abuse Laws. You can watch our program on Mediacom Channel 15 on Sunday afternoon at 1 o'clock. Again, it comes on Wednesday evening at 9:30. You can email us at vocaliowa@mchsi.com or give us a call. My number is 276-3956, and John's number in Des Moines here, area code 515-282-2672. My name is Don Burgmaier, and with me at the controls is my co-host,
John Harvey, and welcome to the CPI report. CPI, that stands for Child Protection in Iowa, and it's those issues in which we spend a considerable amount of time in two different areas. One is to influence public policy as it relates to child protection issues, and secondly, to assist on a one-on-one basis with families who call for our advice and counsel. We're not attorneys, but there are families who once in a while have difficulties with the Department of Human Services and the juvenile court. And we're only too happy to lend assistance where we can to show you how you can protect your interests in your family and to give you some kind of a clue as to what your rights as parents are in this whole scheme of things. Well, we have a General Assembly that is meeting here before long in January in the new year, and we're going to be speaking a little bit today on some of the suggestions that the Homeschool Legal Defense has for what the General Assembly and others having to do with public policy should be thinking about. Because there's a lot of terror that hangs around families. For some reason, government has considered themselves to be the better parent. And whenever that happens, it means that the family's rights are being diminished and being run over. One of the organizations that is attempting to diminish the child abuse is called PCA, Prevent Child Abuse Iowa. And we're not in total agreement with some of the things that they think about with respect to programs that they have distributed around the state. It seems as though they can spend $1 million in doing all kinds of programs that are not even equally distributed throughout the state. One would think that if a program, parent education or something of that sort, is available in one area, it wouldn't be wise to distribute it to other limited areas. But this money is handed out to certain groups, and they can pick what programs they want to work on and how they want to spend government's money. It would seem like to me that if it was something that a community should be interested in, perhaps that community, instead of going to the state legislature, should decide that that community is going to sponsor certain things. They're going to pay for certain things. They're going to staff those projects, and they shouldn't be coming to the state to ask for funding. We're going to take a look. Don, do you have an item that you can put up there? Because we want to take a look at some things that we made mention of last time, but let's see if we can get that up on the screen. Okay, we'll take a look and see what that looks like. What this is a chart of how they're spending some of the funds. By they, I mean the PCA, the Prevent Child Abuse Iowa, seems to be able, in the last many years, of going to the state legislature and asking for money. Now, some of these programs, I think, have a very little payback. In other words, for the amount of money that they're spending, it appears as though there is not much to show for all of these expenditures. They do show that they're spending a lot of volunteer hours and so forth. But what I'd like to do is, with this chart, we're going to go down with something called the Crisis Nursery. Crisis Nursery is one of the areas in which they spend money on 194 families. Notice that in the center. And they have something like 30,000 hours of volunteer assistance. But what I'm more interested in is the fiscal responsibility here, in which you can take the $108,000 and divide it by the number of families, and guess what you get per family. This means that for every family that is given some kind of crisis nursery services, it's going to cost taxpayers $561. Well, that's a pretty healthy sum of money, is it not, out of the Treasury of the state of Iowa for each family that is asking for services. And these services don't necessarily appear in every county. They only appear in counties where there's some interest in assuming the responsibility for providing crisis nursery. We have I think somewhere we have a copy of what crisis nursery does. Just a second here. Do they or do they? Oh, they're available. These funds are available in Buchanan County, Carroll County, Fayette County, Lynn County, Marshall County, and Washington County. Iowa's crisis nursery programs provide temporary place for children ages birth to 12 years old to stay during times that their parents face overwhelming circumstances or emergencies. In other words, when Grandma and Grandpa should be there to watch over them, we're going to use state money to watch over them, have some stranger watch over them instead. The programs are available to families 24 hours a day, 7 days a week, and for up to 72 hours at a time. And programs use licensed daycare centers or registered daycare homes for the actual provision of child care. Their staff intake interviews, counsel parents, and arrange placements for children. That's their responsibility. They may also provide transportation to centers and to travel to pick up the children. So that's something they call the crisis nursery. Then next we have something called the Parent Education Program. Well, Parent Education Program supplies services to some 3,508 parents and adults. So if you divide that 3,500 parents and adults into the $466,000, you get an idea of what it costs to train each of these people in parent education, and that cost is $133.08 for every one of those 3,000 parents. Now, we don't know what the curriculum is for this or how long they spend for each one, but we do know they're spending $133. Respite care is another one where it's just a matter of taking care of children. Let's see if I can get a definition. Respite care programs provide parents with temporary relief from the care-giving responsibilities, providing an out before stress of parenting build up and overwhelm the family. Can you imagine how we ever survived without respite care? But now we have to have respite care that where we have to go to the state legislature and provide it for our families. And doing so, with the number of families that are served, it costs $146 per family to provide respite care. Well, it's interesting to note as we go down through each one of these, sexual abuse prevention is another one. And by the way, the state legislature volunteered to dump another $200,000 into sexual abuse prevention programs, which is rather ridiculous, and I'll tell you why. Number one, sexual abuse amounts to around 6% of all of the abuse cases that are handled by the state of Iowa. Secondly, the sexual abuse programs that they're pushing now is directed toward children. That is, they are the ones that we talk to about sexual abuse. Instead of talking to the ones who care for the children, we now talk to the ones who the children themselves. And the problem with this is that they've done a number of studies that show that is not the most successful way of talking about sexual abuse. You talk to a 4-year-old about sexual abuse and it means absolutely nothing to him. It would be better to talk to the 4-year-old's parents with respect to guarding that 4-year-old from incidences of sexual abuse. Well, that isn't the way they do business here in Iowa. They just go to the state legislature and say, we need that $187,532 in addition to the $200,000 that the state legislature decided to give them anyhow, whether they need it or not. And that amounts, for the number of children that are served in schools all over the state, it amounts to $33.56 per child. Well, they do that in classes in schools, and for some reason the schools are only too excited about having these people come in to the classrooms and talk to the children about sexual abuse. So they get a pretty warm welcome for that. Though there's 47 of those kind of projects around Iowa, so you know it's not in every county. One would think that if a program was valuable, you'd want to have it in 99 counties, right? But that isn't the way they do business here with PCA. Then there's something called the Young Parent Support Program, in which they go and grab $134,000, and they serve 1,491 parents at a cost of $90.02 per parent. And then lastly, this hodgepodge of other funded programs. They spend $8,800 for them, and there's 100 people served, which you can calculate in your head what that is. That's $88.55 per person. Overall, when you look at the way the $1 million is spent, the $1 million, when you divide that by the total number of folks here, which is 10,687, it amounts to an average payment to everybody out of the state treasury of $840.84. You see, that gives you some kind of an idea about how if you can worm your way into the to the good graces of some chairman in the state legislature, you can grab big bucks, spend them any way you please, distribute those services anywhere in Iowa that you please. It doesn't have to be all over Iowa, but anywhere you please to serve people. And then you really don't have to have any kind of accountability. How do we know in these cases where we are training children so that they can empower themselves not to be sexually abused? I think it would be rather interesting to look at the counties in which this money is being spent to see if the rate of child abuse would decrease. What we may find, and I think we've done this in the past, what we may find is that the rate of child abuse increases. Now, here's what PCA then comes back and says, well, if it increases, that means there's more awareness and there's more reports being turned in, so they win. But if it decreases, they'll say, good, we've been successful in decreasing child abuse. So it's a win-win situation for them according to the way that they have constructed their accountability. There is no real good accountability for spending $1 million on child abuse prevention programs. I think we're kidding ourselves in a legislative session when we say that we can prevent child abuse simply by throwing money at it. Schools have been successful at doing that, and I can't say that they've been successful. At least the schools have been doing that time and time again, taking huge sums of money and not producing what they are clearly required to do, and that is to teach children in the basic subjects. They're doing a good job with teaching them athletics and teaching them all of these ancillary subjects, but when it comes to teaching them such things as math and science, they're not up to it, are they? Well, I think it's going to take a real struggle for us to win the battle in the courts and win the battle in and win the big battle in the state legislature, so that when we do spend the public's money, we're doing it in a manner which is required for us as a state to do, and we're doing it in such a way that it covers the entire state, not just little pieces, a county here and a county there. Projects that are interesting in certain geographical areas, but not of interest elsewhere. I think it's going to take a tremendous amount of effort to guide our legislature to doing things in such a way that they make sense, and also to curb the tremendous amount of costs that are involved. You see, I talked to one administrator many years ago who said something fairly simple. He said, there never will be enough money. In other words, you could never satisfy those people who are looking for money in this business of social work, because there will never be enough money. They'll find ways of spending whatever money they can get their hands on from the state legislature. Well, we're also interested in what's happening in the courts, because in our battles with the juvenile court and our battles with the Department of Human Services, we often find ourselves talking to judges, talking to other people who have some rather strange ways of doing business, things that need to be reformed. And our best reformer around this station is a fellow by the name of Terrance Walker. Let's talk to a legal reformer, a person who would like to see this court straightened up. Here now is Terrance Walker.
Thanks a lot, John. Well, I tell you, you give me much kudos every time. I don't know if I can live up to that title as one of the best reformers. No, I'm just a mouthpiece here. I'm the mouth of the Midwest, not the mouth of the South. Mouth of the Midwest, and have a little bit to say about the justice system every now and then. And the self-proclaimed judge of the judges, because nobody else is doing it. Somebody needs to do it, because there's a lot of wayward judges out there, but there's a few good ones out there. Did have a little piece and good article here, good court case, I guess a good decision by a judge for once. And I've made it a point here for 2008. We're going to bring out some of the good judges as well as the bad judges. We're going to point out what the good judges are doing and highlight what is a good judge and what is a good decision. Now, we got from the Electronic Frontier website, Electronic Frontier Foundation. They do a lot of stuff as it pertains to the internet and people's rights on the internet. They have a lot of cases that they fight for, and I think it's good because if not, you might get online one day and all your information is basically handed over to the president or to the NSA or to somebody, and they basically can track you every move. You can't go to any website without knowing where you're going. So it's good that there's a good organization out there like the Electronic Frontier Foundation. But anyway, there was a good article on their website from the 19th and the 21st. Now, there's a situation that's in New Jersey in which a township called Manalapan, I don't know if I'm pronouncing that right. It's a township called Manalapan, New Jersey. And there's a malpractice lawsuit filed by the township against its former city attorney. And there's a blogger that's on a site hosted by Google's Blogspot service. And the writer has termed himself the Truth Squad. And he basically, the blogger has basically, and for those that don't know what blogging is, it's somebody that's getting on the internet just putting some stuff on like a kind of like I don't know if it's what you want to call a chat room or a website that allows you to put messages on there. That's basically what a blogger is. But anyway, the guy or girl, whoever it is basically criticized the whole lawsuit that was filed against his former city attorney, and on top of that, it alleged the township. First off, they alleged that its former city attorney Stuart Moskowitz, they allegedly have him engaged in misconduct regarding the township's purchase of polluted land in 2005. And the decision to file the lawsuit was met by a lively debate in regional press and among local bloggers. One blogger, whose name, like I said, was the True Squad, he basically criticized the whole thing and has basically caused the uproar because the city is basically what they did. They got so upset at the blogger. The attorneys for the township of Manalapan in New Jersey issued a subpoena to Google demanding that the identity of the anonymous critic be turned over along with the True Squad's contact information, blog drafts, emails, and all information related to the blog. And despite repeated requests from the Electronic Frontier Foundation to explain how this could be anything other than an attempt to out a vocal critic, the attorneys for the township refused to withdraw the subpoena that they issued for the blogger to Google and informed the Electronic Frontier Foundation that it could go to court and object to it if it chose. Now, one judge who's on December 21st, Superior Court Judge Terrance Flynn, how about that? Another Terrance out there. Terrance Flynn granted Electronic Frontier's motion to quash the township's subpoena seeking the identity of the True Squad and denied a motion by the township to authorize future subpoenas, finding that the subpoena amounted to an unjust infringement on the blogger's First Amendment rights and that the blogger has a right not to be drawn into the litigation. And I do have to applaud that judge. That's an example of a good judge because nobody should be subject to, being drawn into some sort of litigation just because they're a critic of a lawsuit. That just does not make any sense. Anyway, in some more pressing, well, I don't know if it's more pressing, but in a more wide encompassing case or situation and issue here, which has been in the limelight, in the news for several years, but one that's actually just came to a head here recently. The United States Sentencing Commission, they basically, on the 19th of the December of '07, they basically made they made thousands of prisoners jailed on crack cocaine offenses eligible for reduced sentences. Now, comes after a day after the landmark Supreme Court ruling in which the judges voted 7-2 that the court can depart from the mandatory minimum drug sentences. Now, the U.S. Supreme Court or U.S. Sentencing Commission, or the United Supreme Court, basically ruled 7-2 that federal judges can sentence individuals below the guideline recommendations in crack cocaine cases, and the sentencing commission decisions apply to that ruling retroactively, and that means that more than 19,000 people currently in prison could be eligible for an early release, and the decision could reduce sentences by an average of 27 months. And the commission emphasized the early releases would not be automatic, and federal judges would have broad discretion in deciding each individual case. The Bush administration strongly opposed the move to make the lighter sentences retroactive, and under the current guidelines, possession of 5 grams of crack triggers a 5-year mandatory sentence, while it would take 100 times that amount to trigger a 5-year mandatory sentence for powder cocaine. And the disparity has long been challenged by civil rights groups because crack is often used by African Americans, and then on top of that, it's also more so associated with a lower level street dealer, more so than someone that would be basically importing the drug from another country. So, from a policy standpoint, it actually didn't make any sense. And the United States Sentencing Commission has been actually promulgating this fact to Congress for several years, but because of politics and politicians and demagoguery, they weren't able to actually forge ahead with this recommendation. And then just an analogy, if you're playing football, and we're talking about fairness here, and if you know what holding is, holding in football is when you hold somebody and you're not supposed to, and they don't have the ball. You can't hold the person's shirt and arm and all that, or their body when they don't have the ball. Well, say for instance you have somebody that's holding somebody, and that's against the rule, and they get a 100-yard penalty. But you have somebody that comes along and they take the quarterback and grab him by his face mask, and they get 5 yards. So that's the tantamount. That's the whole fairness aspect of this put into perspective in terms of football. So if you got somebody that's holding a person and preventing them from going without the ball, they get 100 yards, and then somebody that just takes the quarterback and cause not only neck injury or head injury or something like that by grabbing his face mask and does that, but they only get 5-yard penalty on that. That's my analogy on that, and that's why that doesn't make any sense, and that's why the United States Supreme Court basically said it eventually doesn't make any sense. I do have to applaud the justices this one time. I think that I was thinking that the whole crack cocaine thing would have been out of the limelight, and it would have went by the wayside since the recent appointment of several conservative judges. But I do have to applaud their wisdom in this case, because it does make sense. That if you're coming from a policy standpoint, you're trying to eliminate drugs in this country. You don't want to you don't want to put all the low level people in jail, because eventually, at a point, if you just let the high level dealers off with a slap on the wrist, we've got 2 million people in prison right now. I mean, you're going to have 4 million by 2010 if we keep up with this whole rationale and policy justification. So that's my two stories. I didn't really have too much else other than that, but I wanted to put those out there because I do think that's important to share.
Well, certainly appreciate that. And one of these days, someone's going to have to start listening to court reformers' ideas about what to do. If you had one or two things that you would take into the General Assembly this 2008 session, do you have any kind of an idea what would be one of the greatest things that could happen to Iowans if they took your suggestion on one or two measures in the upcoming General Assembly?
Yeah, I would think that. Well, I mean, I've been promulgating the idea of basically having disbanding this whole notion of Judicial Qualification Commission to have an independent citizens body review the courts, not their decisions per se, but the actions of court officers or whatnot. And I think that would stem a lot of the problems in the as far as the fairness of the court proceedings that they have. And then on top of that, I think that the implementation of a citizens grand jury or something similar to the fact like jail promulgates, I think that would be one of my suggestions for the legislature this year, as it pertains to the justices. I could probably come up with a whole bunch of other ones that pertains to other things, but
You bet.
know.
That wouldn't cost anything, basically, would it?
Well, I think if they shifted some money from one thing to the other, yeah. I mean,
Yeah.
because we need some things that are going to work. I mean, if we're in a situation where the Judicial Qualifications Commissions, not only in this state but in every other state, are not really acting on any of the complaints, and they're basically rubber stamping the behavior of all the judges and keeping everything secret as it pertains to the complaints. I mean, there's no idea if we know if any of this stuff is valid. If they're actually doing anything. So that's my suggestion for 2008.
So keep an eye on the
Keep an eye on the course. We got to keep an eye on the course.
That's right. Well, they seem to be a kind of a secret society anymore, an elite society in which we have there's the judges and then there's the peasants, and I think when they sit down there in that marble hall, and they're talking about building another marble hall. Did you know that? An 8-story one for Polk County. For Polk County.
Yeah, I did hear
so,
about that.
awful lot of marble going up, which means to me a push toward even more and more of this concept of the elite and the peasants class. I know that.
And they're trying to put all the peasants in jail. I mean, they got that big facility right there north of 280 here in Des Moines, and that's a pretty big complex.
I went past that the other day. Saw an awful lot of razor wire.
And the funny thing is, well, I guess the ironic thing is, the all the jail officials were for it, and the previous sheriff was for it, and he really pushed for it and everything like that, and lo and behold, they're trying to, instead of staff that with deputies, they're trying to staff that with civil people and lay a lot of the sheriff deputies off. So
Right.
whereas they thought it was a good thing at first, they're coming to realize it's all about the dollar. They're trying to save money and put some people that's off, civilians in there to staff that complex.
They didn't do any real good thinking like you should on any kind of a business plan. They just said, well, we need $68 million to build a new jail, and we're going to make lots and lots of money because we're going to warehouse a lot of federal prisoners. Well, they found out that the cost of warehousing those prisoners is greater than what we're spending. So how do you make a lot of profit in situations where you're spending is greater than your income on federal prisoners. And that's how we were going to save a lot of money. We were going to save a lot of money because we didn't have to take our prisoners down to Missouri to warehouse them.
Well, they're going to charge people like $50 a day. That's what they do, I think, something like that. Yeah, it's about $50 a day or something like that. If you go to jail, $50 a day. So, in some instances, I mean, I could see that might be justified, but if you've got somebody there that's dead broke and poor, and they're in jail for 30 days, and then you tell them, you're going to be released on probation, and you got to pay off all this cost before you get off probation. Well,
Right.
if it's a guy that's below the poverty level, and he's got a kid or two that's child support's taking money for, and he's
Right.
got an apartment that's costing about $500 a month, you're setting up a situation for failure.
That's right.
Especially if he's working at McDonald's or somewhere else that's giving him minimum wage. So,
Now they're worried about the amount of time and effort it's going to take to bring them from that razor wire prison out there downtown to the courthouse for hearings and so forth. So they're spending more and more and more money with less and less thought. And now they want $130 million new courthouse with an 8-story annex to it, and they're going to take the parking lot that we've used up till now to do our courthouse business. Where are we going to park? They don't seem to look ahead on things like that serve the citizenry that has to pay the bills.
We can park out on the street, John, and pay those $20 parking tickets.
That's right. Are they $20? I thought they were $15.
they went up. I know that.
They went up to 20?
I think so. I think they're either
I don't know.
they're
but
pretty
they
high.
were-
I know that.
We're pretty high. That's
they
right.
are pretty high. It used to be a $5 ticket if you went over your
That's
meter.
right. That's
I
right.
think I got one for 15 or 20. I couldn't remember exactly what it was, but I thought it
Right.
was ridiculous.
It's painful either way.
Yeah.
Okay. I told you a little bit ago that we're going to look at some of the suggestions that come from the homeschool legal defense because they're kind of new to the game of child protection. But I'm telling you, they've got some pretty terrific ideas about what goes on, what should be going on here. Well, Don and I are going to take those, and Don, you take ready for number 30, and I'll take number 29. There's a whole raft of them here, and we've gone through 28 of them so far in previous programs. Some of these, or many of these, would require no money, no additional funding. It's just a matter of shifting our way of thinking and our laws so as to maybe accommodating families instead of attacking families. Number 29, require that during any intervention by child protection agencies, any treatment plan devised must include a definite termination point, either a time frame or the completion of certain criteria that upon completion of the time or stated criteria, the children must be returned to the family and intervention must cease. And Don, we've had a tough time in these areas when it seems as though a treatment plan never seems to cease. It's another hurdle, and they'll say when you're just about ready to complete that hurdle, they'll throw another hurdle down for you to complete. So you never can do enough to satisfy the Department of Human Services. Don?
30. Require that any treatment plan be relevant to the circumstances that instigated the intervention, and include an explanation as to why and how each element is relevant and the proposed benefits of each element.
Number 31. Require that states provide for an effective administrative appeal process for any proposed treatment plan. Oh, heavens no. They're waiting 900 in line right now for administrative appeals. including but not limited to presenting the appeal before a citizens review panel. Boy, they certainly don't want citizens review panel. That's something that Terrance was talking about here just a moment ago. Before asking the court to order it, and advise parents in writing of their rights to appeal certain elements of any treatment plan in court for being irrelevant to their situation. This would play havoc with the way social workers think and do their business. Don?
32. Require that the CPS agency prove to the court the necessity of all elements of the treatment plan, or the court must deny the agency's request. Keep in mind, CPS is equivalent to the DHS here that we refer to. And that said proof must include the fact that the parents has a past history of actions that warrant the requested element of treatment, and that said history constitutes a violation of the law. John?
Require that child protection agencies provide written guidelines for dealing with parents who assert their innocence and where there is no evidence of abuse, and have real provisions for immediately terminating intervention and returning the children to their parents' custody when no probable cause can be found to continue the intervention. Now, you see, that just makes sense. It doesn't require a staff. It doesn't require funding. It simply says that when these people complete their contract, here in Iowa they use the term contract, but when they complete their program, their treatment plan, then you return the children. That doesn't seem to be too difficult, as far as I'm concerned, to put this into a legislative scheme. Don?
Require that all child protection agencies provide written guidelines of rights and remedies for complaints against the agency upon initiating an investigation, and that there are provisions of a truly independent citizens review panel to deal with complaints that are not satisfactorily addressed internally, and that said panel is not to be under the influence of or suffer the presence of any CPS agency representative during their investigations, and that the CPS agency is required to follow the recommendations of said citizens review panel. And said panel will have the power to compel evidence to be produced and to compel witnesses to testify before them. John?
Bingo. That sounds like a mighty good idea there. It was a long paragraph, but it certainly sets up what I believe to be some pretty important ideas. And I didn't know that they were pushing so much on this citizen review panel. I've mentioned that to DHS before, and they just kind of poo-pooed the whole idea of having citizens doing things like this. They do, however, Don, get into something called family meetings. But one of the things that would be outlawed, excuse me, in the family meeting here, or wouldn't fit with this particular suggestion, is that the family meetings are dominated by the CPS worker themselves. If you're going to have an overseeing or a citizen review or something, you don't need CPS there to assist in that review. Require that all efforts to place children with relatives be documented in the case file by transcripts of tape-recorded conversations or by certified letters, which unedited tapes are to be made available to any party upon request, which records will include the names of the relatives contacted, including the date, times, and results of the contact. You know, they're doing an awful lot of this nonsense of not placing children with blood relatives when they know there has to be either a temporary or permanent placement of children outside of the home. If they don't like a certain grandmother or aunt or something, they'll say, well, that person is too old, or that person has a history of drug abuse. You know, of course, they haven't used any drugs for the last 27 years, but they have a history of drug usage. So they'll come up with some kind of an excuse not to place the children with a blood relative because, and I think part of the reason for that, Don, is that they don't have the quite the authority over blood relatives. Blood relatives seem to have a greater sense of attachment to the children, and they don't want to be bothered by the DHS or bureaucratic individuals. Don?
Require that all efforts to reunify the family are defined as such in writing and be included in the case file as a reunification report, and that such efforts describe exactly how these efforts are relevant to the family's dynamics and describe how they will benefit the family, and require that these efforts are approved by the parents and validated with the parents' signatures on the said reunification report, and that the parent is permitted to submit their own analysis of the reunification efforts that must also be included as part of the case file and must be presented to the court. Okay,
Number 37. Require that all interviews with children who are suspected of being abused or neglected be videotape recorded in their entirety. I've seen many cases where they'll put this on audio tape or even on videotape, but then they'll stop the videotape so they can instruct the child, give them some clues as to what kinds of mistakes they're making and tell them to do it over again. That particular feature isn't in here where it says that they do it from beginning to end, but I think there ought to be some indication that there's no stopping of the tape. Once you start it, you keep it going until it's over with, and then you maintain that tape. Don?
You made a comment that the DHS worker instructs the child.
Mm-hmm.
There's an incentive in there too when this taping is all over to the perfection of for the benefit of the social worker. Then the child gets to be taken out for pizza and ice cream and all those good things. So.
Yeah, we heard about one of those situations where they would give the children candy and gum and pop and so forth if they answered the questions right. In one case, they said, if you tell us the story correctly, there's going to be a prize for you.
But woe to the parent that gives a delicious snack to their child. They lose their child, but now the DHS gets to sweeten them up. John?
Okay, there's a push here for the right to have their lawyers present, but well, they do say representatives, which I think is good, and that the parents have a right to have their representative present at such interviews. Well, you see, when they say representatives, that means you and I could be there, Don. To represent the children at these hearings, and we'd know whether or not they were badgering the children, and we'd also raise objections at certain points to protect those children in a way that we ourselves know to be proper.
I would guess that in years gone by, 20 years and more, that a parent could have a representative. But then they slowly changed the law to their benefit and made it only an attorney. And if you can't afford an attorney, sorry, DHS will take care of it for you. John?
The part I like about this thing is that such representative is not required to be a lawyer licensed to practice law, and that parents have the right to video and audio tape said interviews themselves, or to have free access to unedited true copies of said interviews upon request. You see, this would really tear a big hole in the system if they were required to give attention to these details, and that all persons present at said interviews must be visible on the videotape at all times. In other words, not peeking through the glass or whatever. And if anyone present during the interview is not visible on tape at any time, it is the prima facie evidence of inappropriate interview techniques, and any disclosures made under those conditions may be rendered invalid in court. Don.
Number 38, require that the CPS agency, its agents, or assigns may not isolate the child from his parents or other relatives unless there is a real threat to the child's life or safety that is substantiated by hard evidence.
They don't work with hard evidence, Don.
And if any CPS agent denies the parents access to the child without said evidence of danger, the agent is severed from immunity from civil and criminal penalties. This, let me reread that first sentence, John. Require that the CPS may not isolate the child from his parents or parents. I remember a case 20 years ago when they took a child and took the child from DHS foster home and put it into CPS child. I forgot what the title is now, but another foster home, and the parents were denied access to their own child for over 30 days. John?
They like to have full control over those children. Require that parents' access to the child be frequent and lengthy, so as to maintain the parent-child bond. I don't know how you do that, Don, because there's no way that if you're going to put one child, in one case I know of a young man, well, he was in middle school, and they put him 110 miles away from his mother. How do you maintain the parent-child bond?
Now, I remember another case where the DHS worker, Candy by name, said to the parent, I'm going to break that bond.
Yeah. So the bond is important, but even though they're demanding this, I'm not sure how you would go about that. Maybe not taking the child out of the home in the first place would be the best way. Relationship, and that CPS agency may not limit visitations because it is inconvenient for the agency. Well, convenience means an awful lot to the agency, whether or not their people can manage to do their job of maintaining visitation. In one case, I know they couldn't do visitations at night because the social worker that would be involved in that was a go-go dancer, and she was working at night, so she couldn't maintain her responsibility of doing that. Don?
Number 40, require an objective, age-appropriate definition of abuse and neglect that cannot be subject to individual interpretation and biases. And in this definition, spanking or slapping in and of itself cannot be construed to be abuse, and that any condition that is statutorily defined as an injury must be proven medically to be an injury that requires medical attention to preserve the health of the child, and that any definition of mental abuse must conform to the science of psychology, not to theory. And up above it says spanking and slapping cannot be construed to be abuse. What was it? Less than 10 years ago, 6 years ago probably, there was a Supreme Court ruling came down and said it is not abuse to slap a child. You remember that one, John?
I don't remember one slapping. I remember spanking, though.
Or maybe it was spanking.
Yeah.
If, as long as there was no injury, the Supreme Court ruled in favor of the parent in this case, and that extremely upset the DHS when they found out that a parent had the right to discipline their own child. John?
Require that the laws protect the practice of the parents' religious beliefs, which do not seriously endanger the health or safety of the child, and provide stiff punishments for agency representatives who remove children from their homes due to the parents practicing their religion. By the way, in Iowa, they'll never admit to the social worker removing children, because that has to be done by court action. However, the courts and the Department of Human Services work so closely together, to me, would make no difference which one is which. Don?
Require laws to protect the right of parents to homeschool their children and to control who the child will associate with, and to control the child's medical care where the life of the child is not in danger by their inaction, and to direct the religious and secular education and upbringing of the children in all cases where there is no clear and convincing evidence of danger to the child's health or safety. John?
You know, I haven't seen any of these that are going to cost a whole lot of money. It's mostly a change in procedure, policy, or statute that would bring about amazing changes in how we look at child protection. Okay, eliminate anonymous reporting and require that the names and addresses of all persons who report child abuse be made freely available to any party to the complaint, and that the accused be allowed to face the person reporting abuse against them in court, and make all persons who report child abuse subject to qualified immunity based on the standards that they knew or reasonably should have known the report of abuse was true and accurate and within the statutory definitions of abuse, and make them accountable for false reports with severe criminal and civil penalties, and require the states to enforce these penalties upon the penalty of losing funding. Oh boy, losing funding, that would be a terrible thing. Would you take the next two or three here, because I'm going to have to watch the
Require the states to advise any child reporting child abuse against himself of the existing criminal liabilities he faces for making a false report. Require all social workers to be licensed and bonded. Require all guardian ad litems to be bonded. Require that GALs, that's guardian ad litems, conduct bona fide investigations on behalf of the child and make the results of that investigation available to all parties, and make the falsification of this investigative report punishable by mandatory fines, imprisonment, and revocation of their license to practice law. Eliminate the requirement for secrecy and sealed records in all unfounded cases, and open these records for public inspection so that the abuse by the system can be exposed.
Okay, thank you for that. These GALs, of course, GALs, I think are unnecessary anyhow. We'll be seeing you next week. Thank you for stopping in.